an authority for the proposition that the citers of legislation of a state or the authority in power to make a subordinate legislation or issue of notification would confer jurisdiction on the High Court or a bench of the High Court to entertain a petition at 226. In fact, this court, while construing the provisions of United Provinces High Court's amalgamation order, stated thus the law thus. The conclusion as well as the reasoning of the High Court is incorrect. It is unsound because the expression cause of action is in an application under 226 would be as the expression is understood, and if the cause of action arose because of the appellate order or the revisional order which came to be passed at Lucknow, then Lucknow would have the jurisdiction. Although the original order was passed at a place outside the areas of Oath. This is important. Very clear, Kusumin God. It may be that the original order was in favor of the person applying for a writ. In such a case, an adverse appellant order might be the cause of action. The expression cause of action is well known. If the cause of action arises wholly or in part at a place within the specified Oath areas, the Lucknow bench will have jurisdiction. If the cause of action arises wholly or within the specified Oath areas, it is indisputable that the Lucknow bench would have exclusive jurisdiction in such a matter. If the cause of action arises in part within the specified areas in Oath, it would be open to the litigant who is the dominant litigant to have his forum convenience. If the litigant has the right to go to the court where part of his cause of action arises, in such cases it is incorrect to state that the litigant chooses any particular court. The choice is by reason of jurisdiction of the court being attracted by part of cause of action arising within the jurisdiction of the court. Similarly, if the cause of action can be said to have arisen in part within the specified areas in Oath and part outside the specified areas, the litigant will have the choice to institute proceedings either at Allahabad or Lucknow. The court will find out in each case, whether the jurisdiction of the court is rightly attracted by the alleged cause of action. The said decision is an authority for the proposition that the place from where an appellate order or a divisional order is passed may give rise to a part of the cause of action, although the original order was at a place outside the state area. When a part of the cause of action arises within one or other High Court, it will for the petitioner to choose forum convenience. So therefore, 226(2) also covers by virtue of this paragraph. 227, there can be no doubt. 226(1) also in that regard, because what am I quashing? I'm getting quashed the tribunal's orders of having not exercised jurisdiction. So therefore, the limited submission I make today is that in a writ of certiorari or a writ of 227 where there is a failure, Calcutta High Court is the authority that should decide and what to decide. Now on Ambika Mills, it is often quoted. Ambika, if my lord comes to page 76 of this compilation, page 76. Yes. Very clearly, if my lord comes to page 79, the very second paragraph, Justice Sinha's after his name, page 79. The issue which arises for our consideration in these appeals relates to determination of the citers of the High Court in which appeals would lie under 35G. It was not deciding 226. It was examining appeal. Now, in that context, their lordship said original authority. Where the location of the original authority is. I'll just show where it says that. Kindly come to page 83.
This is very clearly said, right?
Yes, very clearly said that.
Yes. Paragraph 17 you're placing? No.
Para 12. Para 12, page 82. In fact, the reasoning the Supreme Court gives is judicial anarchy. Because what will happen is, people will start doing forum convenience, forum shopping, not convenience. Para 12. The said decision proceeded on the basis that part of the cause of action may arise in the forum where the appellate order or revisional order is sourced. If thus a cause of action arises within one or other High Court, the petitioner shall be the dominant litigant. Indisputably, if this set of reasoning is to be accepted, the impugned judgment as also the decision rendered in Bombay Snuff would be correct. Before dilating on the said proposition of law, it may be noticed that the decision of a tribunal would be binding on the assessing authority. If the citers of the appellate authority should be considered to be the determinative factor, a decision rendered by the tribunal shall be binding on all authorities exercising its jurisdiction under the said tribunal. The tribunal, as noticed hereinbefore, exercises jurisdiction all over the 3 states. In all the 3 states, there are high courts. In the event the agreed person is treated to be dominant litigant as a result where he elects to file the appeal before one or the other high court, the decision of the High Court shall be binding only on the authorities which are within its jurisdiction. It will only be of persuasive value on the authorities functioning under the other jurisdiction. If the binding authority of a High Court does not extend beyond its territorial jurisdiction and the decision of the High Court would not be binding precedent for other High Courts or courts or tribunal outside jurisdiction, some sort of judicial anarchy shall come into play. This was the reason. So therefore, they go on to say further, I'm not dilating on that further, para 14, 15, they go on to get into that. But then at para 17,
17 is clear on this.
Very clear.
Yes. Notwithstanding 12, 17 it says so.
Exil exists. There cannot be any doubt whatsoever that in terms of 227 of the Constitution as also 222 thereof, the High Court would exercise discretion powers, etc., etc. So once you are in the certiorari jurisdiction, it matters not what Ambika says. Now, my lord, there is another interesting twist to the tale. As an officer of a court, I must also inform my learned friend. This judgment was rendered in May 2007, Ambika.
Yes.
In November 2007,
May 2007.
Yes. May 2007.
Yes.
In November 2007, a diametrically opposite decision is rendered by the Supreme Court, by Justice Prasad. That judgment will find at page 72. And this is relevant.
Just a minute, sir. I'll just mark the date where it is there. May 2007.
That's right. And on November 12, 2007,
Yes.
at page 72, Cannon Steels Private Limited comes to be rendered by the Supreme Court in the matter of customs.
Have you supplied Mr. Satpathy with the call?
Yes, that's good. Right?
No, he has. Have you supplied him with the copies of the? Have you given him the citations?
Yes, Your Lordship, I have forwarded it to him.
Yes, it's very good.
No. Additional today they have filed.
Sir, on your WhatsApp I have sent you.
Today.
Yes, sir. Just now.
Very good.
Page 72.
I've not gone through that.
Cannon Steel Private Limited versus Commissioner of Customs.
Just a minute.
What time?
It's on 12th November.
This is 12 November 2007. 5 months thereafter.
The other judgment was not considered. No.
It was not considered. But then this is also of the bench of the same strength. Parinkirian principle will not apply. Maybe an oversight. Maybe it was not brought to their attention. But see the reasoning.
Sorry. Oh, yes.
Page 73, para 2. Challenge. This appeal is to the orders passed by the Punjab and Haryana High Court dismissing the Customs Act appeal number so-and-so filed under section 130 of the Customs Act dated 8/5/2006 and the order passed in review application dated so-and-so. The High Court held that it had no jurisdiction to deal with the matter as the original order was passed by the adjudicating authority at Mumbai and the appellate order was passed at Delhi by the Customs Excise Service Tax Appellate Tribunal. So what happened was for some reason they went to Punjab. Original order Bombay, Tribunal Delhi, they went to Punjab, probably because they may have had office in Punjab. So Punjab and Haryana High Court threw them away. Then kindly come to para 5. Sorry, para 3. Sorry, para 3. In support of the appeal, learned counsel for the appellant submitted that the judgment in Kusumingot is in favor of the appellant, and on misreading of the decision, the appeal has been dismissed. The learned additional solicitor general, on the other hand, submitted that before moving the Punjab and Haryana High Court, the Delhi High Court was moved, and at the request of the appellant, the High Court permitted to withdraw the appeal wrongly stated by the writ petition. So they had first moved the Delhi High Court, but then they had withdrawn. That was another fact. Now, my lord, comes to para 5. At this juncture, it would be appropriate to take note of what has been said in Kusumingot. So the whole jurisprudence of Kusumingot, the judgment that I read out, Nasiruddin, etc., was quoted. Cause of action, Lucknow, or the para 37 that are read out. Para 6. The appellate order in this case was issued from CSTAT office at New Delhi. In that sense, the Delhi High Court has the jurisdiction to deal with the matter in terms of what has been stated in para 25 of Kusum Notes. The Punjab and Haryana High Court was justified in its view as the original adjudication order and the appellate order were not issued by any authority within its territorial jurisdiction. But no person should be left without a remedy. Therefore, even though customs case number so-and-so was withdrawn by the SSC, we direct the restoration of the said order as indisputably the Delhi High Court has jurisdiction to deal with the matter. Diametrically opposite to Ambika. Now, this court...
No, on the question, the person should be rendered remediless.
Very well, but then they said
Because
that...
by that time, they had already withdrawn that appeal. They had withdrawn that appeal.
So,
there was a justification for passing this.
They could have said that you go to Bombay. They could have said, Ambika, go to Bombay. Supreme Court refused to say that. The submissions, therefore, this conundrum has to be clarified by the Supreme Court.
Yes.
This is not our headache. The monkey is off our shoulder. We are not on appeal. If it was an appeal, maybe the Lord would have had to decide. Fortunately, we are not on appeal. In summary, what applies to...
No, even lately in this Ambika Industries, in paragraph 17, the position has been clarified.
Has been clarified, 226, 227 applies.
I will hear from Mr. Satpathy on this aspect.
Correct. So this is by limited submission.
This is, anyway. So
this is
and when Mr. Satpathy comes up, I will answer.
Very good.
Anything else you want to add, Mr. Ghosh? I think you have clarified your entire all positions.
Right. I'll now leave it to my...
Yes, Mr. Satpathy.
Yes. Lord, so far as without going to merit, the first issue is, kindly see, the section 35B of the Central Excise Act.
Correct. Yes.
The 35B appeal to the tribunal. Any person aggrieved by any of the following orders may appeal to the appellate tribunal against such order. Commissioner against so-and-so, so-and-so. Here is a case, the order was passed by the adjudicating authority of the Bhubaneswar. And rightly, the petitioner has challenged the same before the tribunal. And tribunal passed the order against the petitioner. And the initial jurisdiction to trying the case is in Orissa. They don't have any additional place of business even at Calcutta. So therefore, my lord, against that order, the Act provides that he has to file, if he is aggrieved, then 35G. An appeal lies to High Court from every order passed in appeal by the tribunal on or after 1st day of July 2003. And determining the determined question having relating to the rate of duty so-and-so, so the High Court is satisfied, then formulate a question and answer the question of law. So now in the midst of the proceeding, Lord, now the petitioner challenged the question of jurisdiction with regard to the section of abater has been, the tribunal has put in. The tribunal is not allowing the payment paid and by applying section rule 22 of the tribunal acts, tribunal rules. So now the question arises in the midst of proceeding whether the petition has a cause of action to challenge under Article 226 and 227 of the Constitution and the court without having the jurisdiction. The tribunal is confined to the Orissa, Jharkhand, Bihar, Bengal, Odisha. 4 and 5 states.
Just 1 minute. I want to ask that. Are you then accepting the fact that this court under Article 227 would ordinarily have jurisdiction over a tribunal functioning within the territorial limits of this court?
No, my lord. The tribunal is confined to 5 states, my lord. Orissa, Bengal, Odisha, Bengal, Jharkhand, and Bihar.
Correct.
Right. So, my lord, the original authority has to try the case, my lord. Each and every state has filed a tribunal. Tribunal is then confined to the West Bengal, my lord. Tribunal is confined to 5 states or 4 states. My lord, I may not cover the.
I'm not.
So,
Don't bother on that.
so the
Time is not material. What is
yes.
material is it is not related to one particular state. Several states are there.
Right.
More than one high court is there. I
Yes.
understand.
So, therefore, my lord, if it's arise from the state, then the jurisdictional high court is under Article 2 and the cause of action is arise their state, my lord. And their state means Orissa. The cause of action start from the, my lord, adjudicating authority, my lord. Then cause of action merely a issue raised in the arising out of appellate cannot, my lord, the cause of action to try before this honorable court, my lord. This is the first and foremost, my lord, question, my lord, what I understand the law as it's, my lord. So now the Ambika is very much clear, and Ambika, my lord, the Kushum Ingor also considered in the Ambika. In the Ambika case, your lordship, my senior friend has already placed. If your lordship see the Ambika case, the Kushum Ingots has already been considered and passed the order.
You want,
Page paragraph 28.
you want to place Ambika's? Ambika?
Yes.
Yes. Which paragraph do you want to place?
Paragraph 28.
Just a minute. Just a minute.
Yes, your lords. I'm always now. Milord, I have SCC. I have handed over Milord SCC.
SCC online.
Yes, your lordship, see paragraph 28. Internal page 781.
Yes.
Before the High Court, the decision of the court in Kushum Ingots Always versus so-and-so, wherein one of us was a member, was strongly relied upon, therein the court, while considering the provision of clause 2 of Article 2 to held, the said decision is an authority for the proposition that the place from where an appeal at order or a tribunal is passed may give rise to part of cause of action, although the original order was at place outside the said area. When a part of the cause of arises within one or other high court, it will be for the petitioner to choose this forum. Then, Milord, come to the conclusion. Without Milord burdening your lordship, see the conclusion, Milord.
Not able to follow the paragraph number. Right?
Paragraph 28, Mr.
28.
Mr. Ghosh, page 781.
Yes.
781.
Yes.
You use your SCC online, you'll find it. It's there. Yes, Mr. Sir.
Here, Milord, the Delhi High Court, Bombay Survey, all these cases have been considered.
After paragraph 28, you wanted to place which paragraph?
28, then, Milord, conclusion. This the Honorable Court says, Lord Honorable Supreme Court says, in the last in region stated above, in High Court, 43.
40.
Last 43.
Just a minute. Yes.
For the reason aforementioned, we are of the opinion that the High Court was correct in view. These appeals, therefore, being void of any merit, devoid of merit, whereas to be dismissed. However, the fact and circumstance there shall no order of the cost. Now the sum and substance and the ratio is that he cannot choose his own choice to file any appeal. Milord. He has to follow the cause of action. That is Milord, the Ambika Milord industry. Now your lordship see, Milord, I have come across one judgment of the Madras High Court 2017.
Just a minute. So, do you want to place any other or distinguish any other paragraph from this judgment?
No, not required, Milord. The court has ultimately held in favor of the revenue that he has to file a case where the jurisdiction and cause of action are also.
No, before we leave this,
yes,
I want you to just consider paragraph 17 and respond to paragraph 17, which
17, Milord. Yes, Milord. 17.
Just a minute. Mr. Ghosh has relied on paragraph numbers 12.
Yes.
Initially, he has also relied on other paragraphs. For the relevant moment, paragraph number 12. Then he has relied on paragraph number 13. And then, of course, he has relied on paragraph number 17.
Yes.
So, kindly consider 17. And if you want to...
Before that, Milord, 14. Before that, 14, you'll also kindly have a glance.
Yes. Please.
Furthermore, when appeal is provided under the statute, Parliament must have a thought of one High Court. it is a different matter that the by way of necessity tribunal may have to exercise jurisdiction over several states, but it does not appeal to any reason that Parliament intended, despite providing appeal before the High Court, that appeal may be filed before the different High Court as the sweet will of the party agreed decision of the tribunal.
Right.
Therefore, my lord, the Honorable Court has conscious of this, my lord, intent of the position of law and the statute. Therefore, will conclude that the jurisdictional court having the jurisdiction to entertain the
Is very clear. Paragraph 15 is very clear on
yes,
this.
in this case, the nature, therefore, the cause and doctrine may not be invoked.
This nature,
Yes.
therefore, the cause of action doctrine may not be invoked.
May not be invoked. So now,
It is out of the way, even if I accept
yes, I bow down, Lord.
for a time being without deciding it.
Correct.
Time being, even if I accept cause of action doctrine is out of the way.
Yes.
But still then, kindly place 16 and 17 both.
Yes, Lord, I am coming.
Yes, sir. Kindly please.
Subsection 9 of section 35G, whereupon Mr. C. Harishankar, Learned Counsel, placed strong reliance in our opinion, does not answer the question placed before us. Learned Counsel contained that in terms of subsection 1 of section 100 of CPC, the order of the first appellate court being a decree, the second appeal lies before the High Court subordinate thereto. Next note. There cannot be any doubt, whatever the term of Article 2 to 7 of the Constitution of India and so Clause 2 of Article 2 to 6 thereof, the High Court would exercise its discretionary jurisdiction as also power to issue writ of certiorari in respect of the orders passed by the subordinate court within its territorial jurisdiction or in cause of action as arising wherein, but the same test cannot be applied when the appellate court exercises a jurisdiction over a tribunal situated in more than one state. In such a situation, in our opinion, the High Court situated in the state where the first court is located should be the considered to be the appropriate appellate authority.
Yes.
The Code of Civil Procedure did not contemplate such a situation. It provides for jurisdiction of each court. Even a district judge must exercise jurisdiction only within the territorial limit of a state. It is inconceivable under the CPC that jurisdiction of district court would be exercised beyond the territorial of the district, save in a such matter where the law special provide thereof. But here Miller law provided that against the order Lord 35B, 35G is provided in the Act. And Miller the statute it provided something Miller, we can't go beyond that because it is a fiscal statute Miller. Very limited scope to go beyond the statute. If the statute provides something, you cannot go beyond that. That is a settled principle. I don't want to place in judgment so far as this issue is concerned. Now, my lord, by applying this, my lord, all this judgment has been considered. Now, recently, in 2017, I am placing, my lord, the Madras High Court, my lord, the Super Sales India Limited versus Custom of Central Excess Appellate Tribunal and others, my lord. Here is the same similar question, my lord, question framed by the Honorable Court.
Just a minute, sir. You are relying on?
Relying on the Super Sales India Limited versus Custom and Excise Service Appellate Tribunal 2017 SSC Online Madras High Court. I have already previous date already given.
এগুলো দেখো তো ভেতরে আছে এখানে রাখা আছে এর ভেতরে আছে দেখো you have given in a compilation.
No, my lord, three judgment I have given. My lord, this one is Ambika, second one is my lord the Super Sales India Limited.
Oh no, then you can hand over fair diya do, okay. Yes, Mr. Satya.
Yes, my lord, there my lord lordship has formulated the question. If your lordship see the first phase, the writ of specified mandamus is sought for to quash the order of the district Chennai in final announcement. So after scrutinize the case paper, registrar has written the same, the following question endorsement. When there is an appeal remedy available under 235G of the Central Excise Act and Custom Act 1962, and also as per the order passed by the Honorable Division Bench of WPC not so and so, as categorically stated, the writ petition not maintainable, remedy of the writ is only file an appeal before the High Court under Section 35G of the Central Excise Act under 130 of the Custom Act 1962 when it's applied. There are lots of confined that writ is not maintainable. In 2017. And here all these cases has been considered. And the parameter of 2 to 6 and 2 to 7. Kindly see paragraph 8. Here
Yes.
the Union of India and Guwahati Carbon also considered.
Yes.
After considering the category of judgment of Section 35G of the Centralized Act and on the fact and circumstance relating to determination of the assessed value of the commodity in question for purpose of levying duty under Centralized Act, paragraph 4, 15 and 16 held below. Paragraph 15 is more important. In our opinion, assessee ought not to file a writ petition before the High Court, questioning the correctness or otherwise of the order passed by the tribunal. Here, the petitioner questioning the correctness of the order, stating therein that Rule 22 is wrongly applied in that case. Keeping in mind, I am placing the excise law is complete code in order to seek redress in excess matter, hence may not be appropriate for writ court to enter in a petition under Article 2 to 6 of the Constitution. Therefore, the learned single judge was justified in observing that since the assessee has a remedy in form of right of appeal under the statute, that remedy must be exhausted first. The order passed by the learned singular in opinion ought not to have been interfered with by the division bench court in the appeal filed by respondent assessee. In this view, my lord, if your lordship see the 9 and 10, my lord, para 9 and 10.
Yes.
Lack of jurisdiction would be a ground for invoking the extraordinary remedy under Article 2 of Constitution of India, which is not the one pleaded in this case. Rajkumar Sivare versus Assistant Director of Enforcement AD, Lord. The exception carved out are where there is a lack of jurisdiction at tribunal to take action or there has been a violation of rules of natural justice, where the tribunal has acted under the provision of law which is declared ultra vires. In such case, notwithstanding existing of such a tribunal, the High Court can exercise to grant relief. None of exception is applicable in this hand. My lord, here, my lord, the order has been passed, taking the my lord, assistant of natural justice and in accordance with law, and there is no ultra vires, nothing, lord. On the fact and circumstance of the case, the decision relied upon senior counsel of the petitioner Rajkumar so and so and other, it would not lead support to the content that writ is maintainable. For this reason stated supra, the present decision filed under Article 2 of the Constitution of India is wholly misconceived and that same is not maintainable. So therefore, my lord, in my sub and substance, the writ is not maintainable. If there is a provision enacted by the legislature and given enough authority and power and assistance to the assessee to file under the section 35G in appeal. So writ is not maintainable in the instant case, my lord. Now, my lord, the another case, my lord, Suraj Wool Mill Limited case, my lord, Delhi High Court. That has already been considered in the Supreme Court. Kindly see, my lord, Suraj Woolen Mill versus Collector Custom Bombay.
Yes.
There also, my lord, this is under the Custom Act. My lord, the same, my lord, territorial jurisdiction. If you lord see the first flesh sheet, my lord, the territorial, the place of adjudicating authority situated in the relevant state, reference to High Court to others is not maintainable. Lord, I am not relying on because they are discussing everything, Lord, the statute and all these things, Lord. And ultimately, my lord, the court has given the table of 7.2. Your lordship see 7.2, the table, because the benches and the composition of benches and the jurisdictional states, my lord. You will see paragraph 7.2.
It was an order penalty imposed by DRI Bombay. Now the customs tribunal, coal control appellate tribunal was in New Delhi. So that
Sorry,
the,
paragraph 7.2.
from that order, magnanimous was sought for
Yes,
the appellate tribunal of the state to refer it to High Court.
yes, yes, Lord. Yes,
Seeking 130 hours, seeking a magnanimous to the appellate tribunal,
yes,
take the case to refer it to the High Court.
yes. Dear Lordship, see the page 7.2 for a moment. The table is given, Lord.
Yes.
Dear Lordship, see the title of benches, location, and jurisdiction. The various regional benches. Here we are regional Calcutta. All these states are Assam, Bihar, Manipur, Meghalaya, Nagaland, Odisha, Sikkim, Tripura, West Bengal, United Andaman, Nicobar. This is Eastern Regional Bench.
Yes.
Even considering all these things, Lord, the Honorable Court, Milord, pays, Milord, paragraph 14 and 15, Lord. 13 also, Milord. 13.
Very well.
May I read, Milord?
Yes.
Milord, the present case arises out of the state of Bombay. The petitioner may have its factory established at Panipat in the state of Haryana, but that is irrelevant. The jurisdictional authority is at Bombay. Obviously, it is bound by the law laid down under the provision of the Custom Act or any other law as interpreted by the High Court of Bombay. For the purpose of this case at hand, the petitioner must be held bound by the law as applicable as prevail in the state of Maharashtra, whereat the goods were to imported and whereat the proceeding under the act were concluded. In the case at hand, if this Chigat would have stated the case that then reference would have been made to the High Court of Bombay, and the event of application of the statement of case having been refused, it is High Court of the Bombay which the petitioner should have approached the issuing question to the tribunal to the state the case. The Learned Counsel petitioner cited so-and-so judgment dealing with the doctrine of merger in support of his submission that the order of the Collector of Custom Bombay had merged it to the appellate order of the tribunal, which is having its seat at New Delhi. Hence, the High Court of Delhi has competent to hear the matter. In our opinion, the doctrine of merger has to relevance for answering the question posted before us. Reasoning already stated here in for the foregoing reason, the objection of territorial jurisdiction of the court to hear the petition is sustained. The petition is dismissed. Needless to say that petition shall have the liberty to approach the competent High Court, which is our opinion, High Court of Bombay, for seeking appropriate relief, no order for the cost. Now here is the factory also stating at Panipat. There also the Honorable Court say no, you don't have any jurisdiction because cause of action is elsewhere. So therefore, my submission is, Writ is not at all maintainable in view of the section quantified by the Custom Acts, the Central Excise Act. The Act provides something, and in the midst of proceeding, he cannot challenge.
226 is not maintainable.
226 is not maintainable. So therefore, if it is appeal order, 227 also may not be permissible in view of the appeal provision.
Show me that.
So that is my all in I cannot go beyond, because so far as the merit of the case, Ghansam is something else. I don't want to repeat it again because it may help the petitioner so far as the Ghansam is concerned. What my senior counsel mentioned, but my comments are not so far as the jurisdiction and the cause of action is not at all in this present High Court, under present High Court. He has if any grievance, he may approach the Honorable High Court.
Yes.
Yes, Lord, that's all. That is what my submission.
Short rebuttal.
Only before you start, very well. You complete, give you reply, then I'll put it.
Now, my learned friend, as I heard, as I understood, subject to correction, is saying that it is a case of appeal. It is not a case of 226. Because the very judgment that he read out clearly said that had it been a 226 situation, then this principle will not apply. In fact, the Madras High Court is very clear. All those ingredients of 226 was quoted. So if that judgment that my learned friend relies upon is to be relied upon by this court, then the distinction between certiorari jurisdiction and the appellate jurisdiction will have to be taken note of. And if this court is satisfied that ingredients of 226 exist, independent of 227 or cumulatively with 227, then none of the judgment that my learned friend quotes has any bearing. Because Ambika was on the facts of appeal. In the Madras High Court case, I'll show the issue was there was a writ petition, but the issue was with respect to classification. And therefore, it was none of the exceptions of 226, Whirlpool, etc. was there. That is why they said that this is a classic case for an appeal. They get out.
What Mr. Satpathy perhaps tried to indicate here, jurisdictional issue, yes, we can understand. That the order that has been passed by interpreting the provisions of Rule 22 is an appealable order. That is more or less tried to say.
Right.
And he has relied on the provisions of Section 35B.
Correct.
That is the appellate provision so far as the
Right.
tribunal is concerned.
Right.
35G, High Court. High Court, certainly it has to go to the jurisdictional High Court.
Right. No difference.
The appeal, High Court means 35G appeal has to go to the jurisdictional High Court.
Right. Right.
And he has said that having regard thereto, you cannot really proceed.
Right. No quarrel. No quarrel.
No
with
quarrel
that.
on
No
that.
quarrel.
He has also shown Ambika on this. But the last judgment he has relied on, Suraj Woolen Mills.
Right.
Mr. Ghosh, kindly come to this paragraph. Very interesting paragraph here. Paragraph 13. You see, here it says the adjudication, obviously, yes. Obviously, I'll run for a third line. Obviously, it is bound by the law laid down under the provisions of Customs Act or any other law as interpreted by the High Court of Bombay.
May I read the whole paragraph? Then we will context. The present case arises out of the state of Bombay. The petitioner may have its factory established at Panipat in Haryana, but that is irrelevant. The adjudicating authority is at Bombay. Obviously, it is bound by the law laid down under the provisions of the Customs Act or any other law as interpreted by the High Court of Bombay. For the purpose of the case at hand, the petitioner must be held bound by the law as applicable as prevailing in the state of Maharashtra, whereat the goods were to be imported and whereas the proceedings under the Act were concluded. In the case at hand, if the CGAT would have stated the case when the reference would have been made to High Court of Bombay, and in the event of an application for statement of case having been refused, it is the High Court of Bombay which the petitioner should have approached for issuing a requisite to the tribunal to state the case.
It is not a statute, correct. But still then, this line that as interpreted by the High Court of Bombay,
very well,
law has to be applied.
Very well. That's why I said, if it is a question of interpretation of the provision of the Central Excise Act for imposition of tax, 265, Article 265, levy without authority of law. If the authority of law is being interpreted, any provision of the Central Excise Act, classification, rate of tax, input tax credit eligibility, conditions of a notification, if any of the myriad things under the statute were to be interpreted, and the view of the original appellate authority was to be substituted by the High Court as an appeal court, then yes, Ambika, that is an appeal. That's the classic case of what an appeal court does. At the cost of repetition, let me once again reiterate this point. This is the fine distinction.
Yes.
Distinction between appeal and certiorari. In an appeal, the High Court or the appeal court substitutes the view. So, if the original authority says credit denied for ABC reason, tribunal substitutes the view saying the credit allowed for ABC reason. High Court on appeal reverses it saying the credit denied. Supreme Court in SLP, as a civil appeal, credit allowed. everybody, every higher authority is substituting the view of the lower authority immediately below for cogent reasons. So the appeal is a second view of the matter. That is why my lord says in a review petition is not a second appeal. You cannot reappreciate evidence in a review petition because it becomes functions of issue in that sense. Error apparent has to be there only then. So in an appeal, views are substituted by the higher authorities on merits. Certiorari is an independent jurisdiction. Certiorari searches for natural justice violation, failure to exercise jurisdiction,
Or jurisdictional error.
Exceeding jurisdiction, 14, 19, any other constitutional limitation. These are all exceptions. These are what the certiorari jurisdiction is about. So if my case fits into this basket,
But also subject to the well-known
exceptions of law,
that if there is an alternative,
remedy, I will not. Correct. But then, when there is a failure to exercise jurisdiction, subject to if my lords are satisfied, if there is a failure to exercise jurisdiction, then no alternate remedy can ever apply because he has failed to exercise jurisdiction. He has failed to exercise jurisdiction. What has happened in this case? If the tribunal were to take a view that Ghanshyam Mishra does not apply, or the credit is to be available, not available, then things would have been different. In fact, if the tribunal said you are not eligible for the credit, things would have been a classic case of an appeal. You would have asked for a substitution of a view. What does the tribunal do? Tribunal says, look at my powers. Rule 23 of the CSTAT procedure. For a minute, if my lord sees that rule 23.
yes, I would like to.
Yes. Rule 22.
You have separately annexed that rule?
Yes, it
Yes.
is there in my petition.
Yes. Which page, sir?
I'll just.
About পুরো সেটটা দাও না আমাকে এখানে তুলে দাও
Yes.
না নামিয়ে রেখেছি অসুবিধা হচ্ছে
I'll just point out from my petition. Well, yes, my lord. If my lord comes to grounds, internal page 15, page 15, ground number 1.
yes
Rule 22.
yes.
Continuance of proceeding after death or adjudication as an insolvent of a party to the appeal or application. Where in any proceedings the appellant or applicant or a respondent dies or is adjudged as an insolvent, or in the case of a company is being wound up, the appeal or application shall abate. Which means he says, I can't touch it. I can't touch it. He says, I am bound by my procedure, Rule 22. Rule 22 says that the appeal shall abate. I find that the appeal has been abated. Therefore, I become functus officio. And that I want to read out that finding that he says, if my lord comes to
That I
page,
remember.
page
Anyway,
771.
just show me.
Before,
No, you want to show me? Just show me once.
page 771.
Yeah, I remember. Still there, but still, yes.
Page 771.
That is all marked, perhaps. Anyway, but
Yes.
note of functions of
Yes.
issue. Yes.
He gives the entire universe of functus officio and page 777, para 21.1.
Yes.
Thus, it implies the cessation of the authority to act upon having discharged a duty, statutory function, or the like. As pointed out in the aforesaid commentary, no sooner an award is made and filed in court, the power of arbitration comes to an end. The authority pronouncing the order becomes functus officio. Thus, accordingly, the process of judicial analysis and issuance of order, loosely worded to be arbitrate, is off the shelf once the resolution plan is approved in terms of section 31 of the court. The aforesaid definition analyzes and rulings expressions as conveyed and explained by way of various examples concerning criminal process, arbitration award, order of probate, or such other order made, including that for execution of a stay or any other legal pronouncement by a judicial authority once it is finally dealt with, only lead to the inevitable conclusion that the authority being debarred from acting upon the matter. What else is this? This is a classic case of non-exercise of jurisdiction, saying that my hands are tied. I am nobody, I am a persona non grata. Punctus officio. So there is no adjudication. How does he come to the conclusion that he is a persona non grata? He interprets Rule 22, which is not the scope of the adjudication authority's orders. This is the clinching differentiator. If it was a case where what the adjudicating authority held was reappreciated by the tribunal in favor of the revenue, and I was before this court, yes, then alternate remedy, etc., would have become really surmountable or difficult to get over, because the issues remain the same. Then the rigor would have been far higher and greater. Then the whirlpool exceptions would have been very neatly applied. But here, Rule 22 was not the subject matter of the original authority's order. He invents it, tribunal, and says, my hands are tied. I can't do anything. That he comes at para 24. Para 24 is very clear. We may state that we, in effect, in terms of Rule 22 of the CSTAT procedures, have rendered functus officio in the matter, and the present order in the proceedings is merely in the process of conveying the directive of formalization of abatement. This is the clincher distinction. And my lord, I had other day, and I've been saying this, that the convergence between 226 and 227 on failure to exercise jurisdiction is there. I wanted to show that judgment, Hari Vishnu Kamath, which is the 7 judges, page 20, volume 2, my volume 2 of my compilation. In fact, Hari Vishnu Kamath is one of the decisions that are often quoted by the revenue against us in most high courts. We've learned from the revenue to use this judgment against them.
না কাটতে হবে না, কাটতে হবে না, থাক একসঙ্গে থাক একসঙ্গে
Volume 2, my lord, has?
Yes.
Yes.
So you want to rely on which
Page 20,
of which judgment?
Hari Vishnu Kamath.
Just a minute. ওটার মধ্যে আরেকটা সেট আছে, দাও তুলে দাও। ভলিউম 2 অফ দি কম্পাইলেশন।
Yes, yes, compilation.
এখানে এইটা আছে, আরেকটা কম্পাইলেশন দিয়েছি, দাও তোমার হাতে আছে, দাও। No, 2 same sets are here.
Okay.
এটা ফেরত দিয়ে দাও, এটা ফেরত দিয়ে দাও।
Page 20, my lord, has that? Hari Vishnu Kamath.
ওটা ফেরত দিও। No, that's the same set. This set I already have.
Okay. Whichever version my lords have marked.
No, this is marked portion, it's with me. The second set is not there.
Second set, second set.
Volume 2 is not there.
You have a copy of this? Okay. Page 99.
Yes.
Put 99.
Yes.
Same version?
Yes.
Passport. No. अच्छा दाओ क्विकली करने आशो तो पैरा 24.1 की
Which paragraph?
Yes, my lord. Yes. Para 24.1, page 117. What has that? My lord has that? Page para 24.1. Certiorari
Settled. This is settled.
settled. Certiorari will be issued for correcting errors of jurisdiction as when inferior court or tribunal acts without jurisdiction or in excess or fails to exercise jurisdiction. This is where the convergence is to 227. Then they say, certiorari will also be issued when the court or tribunal acts illegally in the exercise of its undoubted jurisdiction as when it decides without giving an opportunity, we are not concerned. The court issuing writ of certiorari acts in exercise of a supervisory and not appellate jurisdiction. This is the most important thing. The distinction I was trying to draw between appeal powers, substitution of a view. One consequence is that the court will not review finding of facts reached by the inferior court or tribunal, even if they are erroneous. This is on the principle that the court which has jurisdiction over subject matter has jurisdiction to decide wrong as well as right. And when the legislature does not choose to confer a right of appeal against that decision, it would be defeating its purpose and policy if the superior court were to rehear the case on the evidence and substitute its own findings in certiorari. Now see this line, the last line. May I read this paragraph? This is what the distinction between appeal and certiorari comes out. The court, while issuing a writ of certiorari, acts in exercise of a supervisory and not appellate jurisdiction. One consequence of this is that the court will not review finding of facts reached by the inferior court or tribunal, even if they are erroneous. This is on the principle that a court which has jurisdiction over a subject matter has jurisdiction to decide wrong as well as right. And when the legislature does not choose to confer a right of appeal against that decision, it would be defeating its purpose and policy. If the superior court were to rehear the case on the evidence and substitute its own findings in certiorari. So in certiorari, you don't substitute the findings. In appeal, you do. This is the neat point. These propositions are well settled, etc. I'm not reading any of that.
No, not necessary.
So this is what it is, and the same principle once again comes out in Syed Yaqub, another constitution bench. Syed Yaqub ko pata hai.
No, no need to multiply on this. This
Yes, I
is this
didn't.
point, yes.
So therefore, my humble submission is, what applies to appeal cannot be applied here. This is a writ of certiorari 227. Exceptions of 227, 226 exist because the concerned authority has failed to exercise jurisdiction by invoking 22, because Rule 22 was not the subject matter of adjudication by the lower authority. That's the rule.
একবার এটা দাও তো ওই অ্যাসাইনমেন্টের অর্ডারটা দাও তো আছে তো অ্যাসাইনমেন্ট কোথায় দেখি দেখি 227 বলছে এই অ্যাসাইনমেন্ট আছে
So limited to file a written submission if my lord permits. No, no need.
if you want to file
No, no, no. There is no need. I don't want to trouble my lord. My lords have heard it. Let it be. When the judges say no need, which means
no no no, no. I never stopped anyone. If you want to
we don't want to
file one page,
Very
one page. If you
One
want
page
to file just one page,
the bullet points of submission.
then if you want to file it, tell me when you file it, I'll reserve it on that day.
No, no, my lord may reserve it today. Then I don't need to, because we don't
No,
want to
you
have
come
the
and file.
hearing, right? What do you say?
Monday, come back on Monday.
You file it on Monday. Difficult, my lord.
Tell me when you want to file.
Next week.
Because Mr. Satpathy, you want to
Yes,
file anything?
No, no, my lord. No,
Very well.
I don't want to file anything.
My lord, we are not going to file it. My lord may reserve it.
Only one thing. Only those, not necessary, because I have noted the judgments which you have shown me. All the judgments you have not shown me.
Absolutely not.
So in case of any, you can do one thing. You can give me the list of judgments cited by him, Mr. Ghosh. Only those list of judgments cited, nothing more than that. So in case I miss out something, I'll be including them. And your judgments have to, you
Yes.
have done on 3, so it's already there. I show. Hearing concluded, judgment. I'm concluding this. You'll submit the list only. Or
So, that on that administrative side, he can give.
yes,
Reserve it.
that is not necessary.
Well, I reserve the order. Conclude.
Already, I've reserved it.
I'm so obliged.
Hearing
for patient
concluded,
hearing.
judgment reserved.
I'm so obliged for patient hearing.
Yes. Much obliged, ma'am.